It's time for On Point, where we speak to experts to delve into some of the key issues in the spotlight right now. In January of last year, the National Assembly passed the Serious Accident Punishment Act, which imposes criminal liability on individuals and entities responsible for serious accidents, which, by the way, came into effect 6 months ago today.
But has the law changed the working conditions for those at greater risk of serious accidents at work, especially in the construction field? We find out as we connect with Kim Sung-jin, attorney at DR AJU LLC. Very good morning to you. And well, first off, can you give us the key points to the Serious Accident Punishment Act, or SAPA, which came into effect 6 months ago?
Before I tell you about the key points of the SAPA, I'd like to briefly explain why it was enacted in Korea a year and a half ago. We've had the Occupational Safety and Health Act, or OSHA, since the early 1980s, but industrial accidents have not decreased. The Korean parliament researched why industrial accidents are not decreasing and concluded that it's because not the CEO, but the plant manager or the head of a contractor is responsible for industrial accidents. So the Korean parliament enacted a new act to decrease industrial accidents by holding CEOs criminally liable for industrial accidents. About the key points of the SAPA, the most important point is that the CEOs are now responsible for industrial accidents, as I just mentioned. Another important point is that the SAPA protects not only employees, but also every person who works for the employer for its business. That means that a worker doesn't have to have a direct labor relationship with the employer. According to the previous act, only employees who have a labor relationship with their employers were protected. Yet another important point is that the place where the SAPA is applied is broadened. According to the SAPA, as long as the industrial accident occurs during the course of business, that the employer effectively governs, operates, or manages, the accident is protected by the SAPA. According to the previous act, only the industrial accidents which occurred in the workplace were protected. So motorcycle accidents that occur in the course of food delivery are now protected by the SAPA.
So, like we mentioned, while the law was, again, put in place to protect workers, employers were sort of opposed to the introduction of this very law. Can you tell us why they were actually against the law?
Well, employers have been against the SAPA since it's holding employers criminally liable with so many unclear terminologies. The first thing I'd like to mention as an unclear terminology is responsible management personnel, or the RMP. The RMP is a very important terminology since most obligations and punishments under the SAPA are targeting the RMPs. However, the SAPA is not stipulating who's included in the RMPs. The second thing I'd like to mention is relevant laws related to safety and health. The SAPA is mentioning relevant laws related to safety and health here and there, but companies are having a hard time finding out what are relevant laws related to safety and health, since each company has a different business. Thirdly, the SAPA is emphasizing effective domination, operation, and management, but it's really hard to tell what can be evaluated to be effective domination, operation, and management. Last but not least, under the OSHA, a company that ordered construction work does not have to perform the safety and health obligations unless the company generally manages, oversees the construction work. In this situation, it's unclear which safety and health obligations under the SAPA are applied to a company that ordered construction work but does not generally manage and oversee the construction work.
Well, it seems that both unions and businesses have been quite unhappy with this law, given its vagueness that you mentioned, and the union administration's been seeking to revise it, of course. But have we seen any positive impacts of this law since it came into effect?
The Ministry of Employment Labor published a statistical report last May regarding death cases caused by industrial accidents in the first quarter of this year. According to the report, the death toll in the first quarter of this year decreased by 8. So if we look at the official death toll, the overall working conditions in Korea have been slightly improving since the SAPA came into effect last January. What's quite interesting in the report is that the death toll in the workplaces where the SAPA is not applied is not decreasing. The SAPA is not applied to workplaces with less than 50 regular employees or less than 5 billion won construction costs. For those small workplaces, the SAPA is applied from January 2024. About the major cases involving the SAPA, I'd like to briefly explain the first case that was passed on to the prosecution. The first case occurred at Dusung Industrial Company, which is an air conditioner parts manufacturer in Changwon. Last February, 16 employees of the company suffered acute poisoning due to chloroform, which was used to clean air conditioner parts. According to the investigation of the Office on Employment and Labor, the company used too much chloroform to clean air conditioner parts. The amount of used chloroform was 6 times the standard of permission. Last April, the Office of Employment and Labor sent this case to the prosecution with the opinion of an indictment. The prosecution is currently reviewing the case to decide whether to indict.
So again, it does seem like there's the good and the bad right now, but the fact is it's only been 6 months since the law did come into effect. So, I mean, do you think the law is good enough to protect the workers at this point, or is there a need for more improvements so that would make surely everyone happy?
Well, even if the SAPA is an important law to protect workers, it alone is not good enough to protect workers. So legislators are discussing other laws to further protect workers. What's currently much discussed is the Decrepit Facilities Act. According to the Korea Industrial Complex Corporation, most casualties in the industrial complexes occurred in decrepit industrial complexes which were developed more than 20 years ago. For example, 3 workers were injured by an explosion accident last month in Yeosu Industrial Complex, which was developed more than 50 years ago. In addition, last February, 8 casualties occurred in an explosion accident in the same industrial complex. In this situation, a member of parliament proposed that the Decrepit Facilities Act is necessary to protect workers. According to the proposal, not only the company which owns decrepit facilities, which were built more than 20 years ago, but also the central and local governments can manage the decrepit facilities. According to the proposal, local governments can open management and improvement plan for decrepit facilities to the public and ask for investigation or directly investigate decrepit facilities. However, since the act is restricting the right to private property, the backlash from employers is quite obvious. So whether the act can be really enacted is very uncertain at the moment.
Kim Sung-jin, attorney at DR AJU LLC, thank you very much for your insights this morning.
Thank you.